So Dr. Anderson, I'm real curious about this. As a historian, you know about a lot of the history of the Supreme Court, and you've even questioned, why blacks even seek justice in the court system. I've heard people say that. I've heard people say that, that the whole system was designed from the beginning, just by the nature of who was on these high courts and things like that. It was designed from the beginning to keep black people in our place. If you look at the history of the court, there's never been a black woman on the Supreme Court ever. And there's been two black men and really only one black man, because the other black man was very anti-black. What do you think that we're, at what point, in what way do you think that we can even look to this court system to even give us any kind of justice?
Black folk are looking in the wrong direction, looking for the Supreme Court or any of the major court systems to bring about justice for black folk. Let's go back to the original intent. When the Constitution laid out specifically what blacks would be in this country forever, unless you attack and readdress those issues. When the United States authorized and approved the Constitution, it spelled out what black folks' role would be in the society. And as a matter of fact, in 1789, they defined it for black folks, saying black folks shall be a subordinated group of people, and they'd be a labor class, valued as 3/5 of a human being, to bring forth comfort and enrichment for the white society. That's basically what it was saying. And they used the United States Constitution as the first affirmative action plan in the country to maldistribute almost 100% of all this nation's land, minerals, rights, businesses, income, privileges, and rights into the hands and controls of government to the hands of the dominant white society. And once they did that in 1789, the following year, they set up what's called the immigration laws and says, now we can bring in anybody in this country, Dr. Watkins, who can pass for whites, and allow them to have all these benefits and privileges and rights and wealth holding and unearned income that we're going to deny black folks. That was in the 1790 immigration policy. And once they set that social construct into place, then they said, how do we make sure this thing stays intact? So then they set up the United States Supreme Court. And the United States Supreme Court came into existence to maintain the whole purpose and intent and the goals and accomplishments that will occur as a direct result of slavery. That is the primary purpose of the United States Supreme Court then, at that point. And black folk never really understood this. And so, because it stayed pretty well hidden up until about 1803 with the Marlboro and Madison decision, where the Supreme Court finally came out of the closet and rendered a decision then. But that was not based on race when they came out. They were talking about a state issue. But the United States Supreme Court has only 3 authorities. 1, they can get involved in any kind of lowercase rulings in the court system. 2, they can get involved in the dismissal of a federal employee. 3, they can get involved in ambassadorial appointments, and that is it, period. But they never were allowed to get involved in overruling Congress. Now that's the key point, that they were never authorized to overrule Congress. Now watch what happens now. So jump from 1803 up to 1857, Dr. Watson. In 1857, for the first time, the issue came up about black folk, because at that point in time, the whole abolitionist movement, they were talking about freeing blacks. And so in 1857, a guy named Dred Scott went to the courts to see about getting some freedom, because he had moved from Missouri up to Ohio and moved back. He said, I should be free now. I left enslavement territory. But the Dred Scott Supreme Court came out and said this: Judge Taney ruled that black people, or black men in general in American society, had no rights that a white person was bound to respect. That was the first time in the history that the Supreme Court came out of the closet and laid out their rulings for the future, that no black man had a right that white folks were bound to respect. And see, but from 1790 or 1789 up to the Dred Scott decision, and the Civil War. Here's the point now, boys, is that point. See, they had appointed 57. You had 57. The first 57 Supreme Court justices were white slave owners. I'm gonna give it to you again so you understand this. The first 57 appointees to the United States Supreme Court were white slave owners. So by 1857, when the Dred Scott came in, those are all white slave owners, period. And now since the Dred Scott decision, after blacks were freed, they've appointed about another 67 people to the United States Supreme Court, bring up to about 123, 126 or 27 appointees. And all of them have basically been whites except one and one half. They had one black man on it in 1950, and they got a half a black on it now who's pretending to be black. And so here's what you should be, here's the point, is that what the Supreme Court was saying by appointing all whites, even at the present time, you got nine on the Supreme Court, 5 white men and 3 white women. And what they're saying is that justice will be dispensed for black folk in this country, whether it started in 1790 with slavery up to the present time, based on justice being viewed through the eyes of white men and the white Supreme Court. You understand that point? That's why, and so consequently, the people, you got black robes and white skin underneath it. Whites see justice for black folk through the eyes of white skin underneath black robes. And that's why up to the present time, if black folk have said, hey, this issue going on in the Supreme Court, it is discriminatory in every respect and immoral for you to appoint 126, 127 people to the United States Supreme Court and only appoint 1 black person in all those years. And so they had made it a racial issue and said not only is a racial issue, but go back and says if you look at every issue and every ruling by the United States Supreme Court, it's always been negative blacks. They've never ruled in favor of black folk. Some people might say, well, Dr. Ezra, what about the 1954 Supreme Court? That was negative for black folk. They changed the desegregation law over to social integration, which wiped black folk out and disintegrated blacks. But you followed the whole thing through the system. I could track it down, but we don't have that kind of time unless you want me to. We can walk through history.
I think we should walk through history because here's the thing. We don't get this in school. When they teach us history, they teach us that the Supreme Court is perfect and that that the checks and balances of the system is perfect and all this other stuff. And then when you go out and you are in an imperfect world, where it just seems like black people always end up on the bottom of the pile, it's confusing to people. It's very confusing. So I personally think if you want to march through some of the key decisions that were made, some of the key things, like just the fact, for example, how many of y'all who are listening, how many of y'all knew that, 56, the first 57 members of the Supreme Court were slaveholders? How is a slaveholder going to make a fair decision on behalf of a slave? They're not going to be able to do it. So I would like for you to march through the history, if that's okay with you.
You're fine. Well, let's walk through it now. I stopped talking about. I brought you up to about 1860, up to the beginning of the Civil War. Now the Civil War came out, and at that point in time, blacks were still underneath the Supreme Court being dominated by slave owners and following the Dred Scott decision. But after the war was ended, and 4 years later, here's what happened. And 4 years later, you had a few liberal Republicans that came into office. They called them radical Republicans. And they said, well, that since we got some mixed kids, black kids, because as members of the United States Congress, we got some black mistresses and black kids, and we understand the Dred Scott decision of 1857, we must do something to give black folks some rights, because in the Constitution, it defined black folk in a negative sense. They met for a full week to say, how do we define black folk? So in the Constitution, when they talk about we the people and all the people, they're talking strictly about white people and talking about black folk. When you look in 1791, when they enacted the Bill of Rights says that all human beings got God-given rights for life, liberty, and pursuit of property. And see, the black folk were defined as property. They changed it later on in the second right and took out the property and put in happiness in there. But here's what we'll do. They met for a whole week and came up with this conclusion. What we'll do in the Constitution is when we're going to talk about white people, we use very special, broad terms like we the people, all the people, the citizens, and now it might be Joe the plumber. When we talk about black folk who are going to be screwed over in the Constitution, we'll make sure they stay anonymous and ambiguous. Never point them out. Let other people know who we're going to make it. So who we're going to deal a raw deal to. In this society, we have two kinds of people, screw-ers and screwees. Whites going to be the screw-ers and blacks going to be the screwees. So what they said, when you look at the Constitution, it says when they label blacks as being those who are indebted, those who are in bondage, that specific kind of species of property, those that unhappy lot, those are 3/5 of a human being, those who are equal to a field animal. They're talking about black folk. That was laid out in the Constitution so that everybody understood that, but without black leadership. They never understood the difference between how whites was related to and referred to in the Constitution versus blacks.